Good afternoon. Once again, this is Dr. Olu Asekun here. Welcome to our live podcast. Today is another Wednesday. This program is every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. Today, we'll be discussing removal defenses for those people who are in removal proceedings. So if for any reason you find yourself in removal proceedings, what options are available for you? So we'll be starting the series from today, available defenses in removal proceedings. So today we'll be discussing cancellation of removal. Meanwhile, before we discuss cancellation of removal, I want to quickly talk about the preliminary issues in the removal proceedings. When you are in removal proceedings, it simply means that you have been given a document called NTA, Notice to Appear. So that means either an application you file with USCIS has been denied and then they put you in removal proceedings, or maybe you file an asylum and you have been interviewed and the officer decided to issue what is called referral notice and then issue notice to appear. Or you may even be a permanent resident and then maybe you were arrested for some crime. As far as immigration is concerned, if you are a permanent resident and you are convicted of a serious crime, especially aggravated felony offense, you can still be placed in removal proceedings. Another thing that can take you to removal proceedings, maybe you walking through a border and you decided to apply for asylum. In other words, you came in EOIR, entry without inspection. And then maybe at the port of entry, you decided to apply for asylum. So again, you will be placed in removal proceedings where you will have the opportunity to present your asylum application. Another situation where you can find yourself in removal proceedings, maybe you enter the U.S. or you attempt to enter the U.S. legally, maybe with a visa. But for some reason, the CBP officer decided to place you on secondary inspection. And then maybe along the line, they decided that you are inadmissible. And they tell you that you are going to be returned to your home country. At that stage, if you tell them that you have a fear of returning to your home country, then they will give you the opportunity to apply for asylum, and then they place you in removal proceedings. And of course, apart from all of this, depending on the administration, some of us will recall that during the last administration, during Donald Trump administration, even people who didn't do any of these things I've listed were still placed in removal proceedings. During Donald Trump's administration, because of the high enforcement rate, people who just overstayed their I-94, they could go to their house, knock on their door, and then arrest them, process them, and place them in removal proceedings. During Donald Trump's administration, there were a lot of people who didn't file anything at all with immigration. But immigration officers, ICE officers, went to their apartment, got them arrested, and placed them in removal proceedings. So all of these, again, could be other things that can place people in removal proceedings. Now, when you are in removal proceedings, the charging document for removal proceedings is a document called Notice to Appear. Notice to Appear. Removal proceedings is the same thing as what we used to call deportation proceedings. However, the term, the language has since changed. It used to be deportation proceedings when the government used to issue a document called order to show cause. Order to show cause. So in other words, at that time, you have to show cause why you should not be removed from the United States. So at that time, it was called deportation proceedings. However, the law has since changed. So right now, you get a notice to appear in a removal proceedings. Of course, when you go to when you face an immigration judge or you were asked to come to immigration court, there are different types of proceedings. But today we are just discussing removal proceedings. There are rescission proceedings. There are asylum only proceedings. There are a lot of other proceedings that could go on at the immigration court. But for the purpose of this podcast today, we are discussing only removal proceedings. Maybe in subsequent editions, we will be discussing rescission proceedings. Rescission proceedings are actually carried out only for people who already have permanent residence. So if immigration believe that you obtain your green card illegally or through fraudulent means, they have two options. They could put you in removal proceedings. They could also put you in rescission proceedings. Well, the proceedings are different. The jurisdiction of the court on each of these proceedings are also different. And the benefit, the relief that a respondent could apply for, they are also different. In summary, in a rescission proceedings, the respondent does not have the opportunity to apply for relief because the only issue before the court, before the immigration court, is whether or not the green card should be rescinded. That is the only issue. So the court is not going to give you the opportunity to apply for any benefit or anything. They just want to determine whether the green card should be taken away from you. So actually, rescission proceedings is very, very dangerous because once the court takes the green card away from you, it prevents you from applying for those reliefs that only a permanent resident can apply for. Because there are some reliefs that only a permanent resident can apply for. So if you are placed in rescission proceedings and the green card is rescinded, that means that you will no longer be able to apply for those benefits like what we call EOIR 42A. You will no longer be able to apply for that. You will no longer be able to apply for 237A1H waiver. Those things that are exclusively for permanent residents. So if you are placed in rescission proceedings and then the court decided to rescind your green card, then you will no longer have the benefit of applying for those reliefs that a permanent resident could apply for. So that is one of the major differences between a rescission proceedings and removal proceedings. But like I said, for the purpose of today, we are discussing removal proceedings. So removal proceedings are usually triggered by a document called NTA, Notice to Appear. Usually, depending on your circumstances, Notice to Appear will have an average of 4 to 5 allegations. Usually, allegation 1, you are not a citizen of the United States. Virtually every NTA, irrespective of your category, every Notice to Appear will have that first allegation. You are not a citizen of the United States. The reason why this is important is that a U.S. citizen cannot be placed in removal proceedings. So that is why it is important to know that every single Notice to Appear starts with that first allegation. You are not a citizen of the United States. That's going to be the first allegation. Now, Usually, the second allegation, they will mention your country. You are a citizen of Mexico. You are a citizen of Sudan. You are a citizen of England. You are a citizen of Nigeria. You are a citizen of maybe Germany. Whatever your country is, usually that will be the second allegation. Now, the third allegation, depending on your category, if you are one of those people who did not enter the US with a visa, then the third allegation will say that you entered the United States without a visa. If you enter the United States with a visa, but you overstay your I-94, the third allegation will state that you were admitted to the United States on so date with authorization to remain until so date. Then the fourth allegation, the next allegation will usually say that you stayed beyond the period authorized. That is for those who entered with a visa. If your situation is different, let's say you entered as a student, as F1 student, the NTA will state it that you are admitted as an F1 student with authorization to attend XY school. Then you're convicted of a crime of moral turpitude, or you are convicted of a crime involving aggravated felony, or whatever the nature of the crime is, that is what the next allegation on the NTA will state. Now, after stating all of these allegations, then the NTA will cite the relevant the relevant portion of the law that you are violating. So the NTA will cite the relevant law that you have violated this particular section of the law, and the government is charging you under this particular law. So now, once you get to the immigration court, the first question the judge is going to ask you, usually in a removal proceedings, the judge will expect a respondent to have a lawyer, because it's a complicated proceedings. It's not like a USCIS filing where you can just fill some forms yourself and submit it. This one is a complicated situation. It involves a lot of legal process. So usually every immigration judge will ask the respondent, do you need time to get a lawyer? Organizations that provide pro bono. Pro bono means free legal service. So the court will give you such a list to try your luck and see if you can get representation. But usually the court, excuse me, the court will give you enough time to try to get a lawyer to represent you. Now, once you have a lawyer, the next question the court is going to ask you is, did you receive the NTA, the notice to appear? Usually your lawyer will answer, yes, we received it. Then the next question will be, how do you want to plead to the allegations? And one thing I want you to pay attention to, if you notice the way I've listed those allegations, you are not a citizen of the United States, you are a citizen of XYZ country, you entered the United States on or before so date, with authorization to remain until so date, you remain beyond the period authorized. These are allegations that you are not going to be in a position to deny. So did you receive the charge? This is the charge against you. How do you want to plead? Guilty or not guilty? 2, the standard of proof in immigration court is not beyond reasonable doubt, unlike criminal cases. The standard of proof in an immigration court is what is called preponderance of the evidence, which means that you put the evidence, you put it on a scale. So does the scale, which side weigh in favor of you? So if you look at the way those allegations are stated in the NTA, as I've repeated it, you are not a citizen of the United States, you are a citizen of XYZ country, you enter the United States on or before so date with authorization to remain until so date, you remain beyond that period. There is no way you can defend any of those things. there is no way you can deny any of those allegations, because those are allegations that are based on facts. So 99.9% of the time, or let me just say 99% of the time, the judge will conclude that the government has proved their case. They have proved the allegation in the NTA the moment you plead to the NTA. Because like I said, there is nothing in the NTA that you are going to be able to deny. You are not a citizen of the United States. You can't deny that, because if you are a citizen, you will not be in removal proceedings in the first place. So you are not going to be able to deny it. Of course, you are a citizen of XYZ country. They will present your visa. You came in with a visa. You apply for visa. You came in with the passport of this XYZ country. So those are things that you are not going to be able to deny. So at the end of the day, the court will conclude that the government has proved their case. Now, that means that the government has met the burden that you are removable. So once the court says that, then the judge will turn to the respondent again, or the respondent lawyer, as the case may be. Now that removal has been established, will you designate a country in case removal becomes necessary? Now, the respondent or the respondent lawyer will now have to designate a country, usually the country where the respondent came from. Of course, you probably use a passport from your country, so you have to designate that country. However, in some cases, for example, somebody who intends to apply for asylum and does not want to go back to that same country that he or she has a fear of returning to. So the lawyer in such a situation can tell the judge that I respectfully decline to designate a country. Because let's say, for example, I'm from Mexico and my plan is to apply for asylum based on the fear that I have returning to Mexico. So if they ask me to designate a country, I will tell them that I respectfully decline to designate a country. But of course, whether you designate a country or not, the government or the court is going to help you to designate a country on your behalf. Whether you have a fear of returning to Mexico or to any other country for that matter, the fact that you have a Mexican passport which you came in with, the court will use that as the basis to designate Mexico on your behalf. So that is the way that works. So after that process is completed, then the judge will turn to the lawyer again. Now, tell me, what relief are you seeking? What relief are you seeking? That is when the... Hold on a minute. There's a message that just came. Okay. I've been a little distracted. Now the judge will turn to your lawyer at this stage and ask that question. What relief are you seeking? So it is only at that stage that your lawyer will now look at your case and present a relief to the court. So, having explained that preliminary process, one of those reliefs that you can present if you are eligible is what is called cancellation of removal. That is what we are discussing today, cancellation of removal. So there are several reliefs. We'll be discussing them on weekly basis until we exhaust most or all of them. But for today, we are discussing what is called cancellation of removal. Cancellation of removal. So in the meantime, let your questions start rolling in. Let your questions start rolling in. We are discussing cancellation of removal today. Let your questions start rolling in. Have you started receiving questions? Okay. Yeah, I want to see those questions so that I can start answering them. Okay, I have a question. Um, Hello, sir. Can you? Oh, what's going on here? Hello, sir. Can you speak about the latest issues with respect to the EB4 visa category with priority date moving backward? How long will the person who filed green card with priority date of January 2021 religious minister expect to receive? Well, this is not what we are discussing today. I would suggest that you go back to one of our previous podcasts where we have discussed this extensively. Right now, we are discussing removal proceedings, defenses to removal proceedings. We are discussing reliefs when somebody is faced with removal proceedings. That is what we are discussing today. So we have previous podcast where this issue you are raising has been dealt with extensively. Go back to look at our podcast on religious minister. I believe that you will find answer to those questions. And if we have time, we can go back to that. But for today, we are discussing defenses to removal proceedings. Defenses to removal proceedings. That is what we are discussing today. So please send in your question. The first defense that we are discussing today is cancellation of removal. Cancellation of removal. Question about cancellation of removal. I am not currently in removal proceedings. Is there a way that I could apply for non-LPR cancellation of removal? Okay, that's a very good question. Well, the answer to that, as I said earlier, today we are discussing defenses to removal proceedings. So if you are not in removal proceedings, you cannot apply for cancellation of removal. It is not something that USCIS can do. There is a difference between the authority of the USCIS, that is United States Citizenship and Immigration Services. There's a difference between their authority and the authority of the immigration court. They are not the same. They operate under different rules. They operate under different departments. USCIS, United States Citizenship and Immigration Services, they are a department. They are a branch under the Department of Homeland Security. So under the Department of Homeland Security, you have United States Citizenship and Immigration Services. Those are the agencies that process applications that are filed with immigration. Under this Department of Homeland Security, you have Immigration and Customs Enforcement, ICE. Those are the people that enforce immigration laws. They are the branch, they are the agency that arrest people who violate immigration law. They are the agency that they have a legal department under that agency. They are the one that goes to court to act as prosecutors to prosecute somebody they attempt or they intend to remove from the United States. They are the one that does that. So under the Department of Homeland Security, you have another agency called CBP, Custom and Border Protection. They are the one that determine who to admit into the country and who to deny entry into the country. So all these three sub-agencies, USCIS, ICE, and CBP, they are all agencies under the Department of Homeland Security. The courts are completely different. The courts are not they are not part of Homeland Security. They are not part of immigration. They are not part of all these things. The court is an independent body under the Department of Justice. Immigration and Customs Immigration Court, they are under the Department of Justice. They are not part of Department of Homeland Security. They are part of the Executive Office of Immigration Review, what we call EOIR. They are under the Department of Justice, so they operate independently. So the same way USCIS will come and present their case in court, the respondent will also have the same opportunity to present their own case in court to defend themselves or present a relief. So cancellation of removal is not a relief that USCIS can grant. They do not have the authority. It is a defense in court. It's a defense against removal proceedings in court. So if you are not in removal proceedings, you do not have the opportunity to apply for cancellation of removal. So let's go on to the next question. Follow up from above. Can I ask USCIS of those are the things that USCIS adjudicate of those are the things that USCIS adjudicate when you have an employer file a petition on your behalf. Those are the things that USCIS adjudicate. If your case involves interview, they invite you for interview. Those are the things that USCIS adjudicate. USCIS is not an enforcement arm of immigration. That is why somebody can have a criminal record and go to USCIS office and they will not be arrested there because they are not the enforcement arm of immigration. It is very, very important that we understand all these different roles. The enforcement arm of immigration is called ICE, Immigration and Customs Enforcement. They are the one that enforce immigration laws. They are the one that determines whether they want to issue NTA or not. They are the one that determines which lawyer will go to court to go and prosecute the case. They are the one that handle all these things. Even in a situation where USCIS recommends NTA to be issued, or even where USCIS go ahead to issue the NTA will still be referred to ICE, Immigration and Customs Enforcement, because like I said, they are the one that goes to court. They are the one that determines whether to file the NTA in court or not. They are the one that determines whether to use prosecutorial discretion. They are the one that determines whether to have your case dismissed from court. They are the one that determines whether to agree to a joint motion to dismiss or joint motion to reopen. They are the one that have all these powers, not USCIS. So USCIS cannot help in this case. Next question. I've already been ordered removed. Can I still apply for cancellation of removal? Well, before I go before I answer that question, I've not even had the opportunity to explain the requirement of cancellation of removal. So I think it is important to even understand what the requirement is before you ask the question whether or not you can apply for cancellation of removal. Now, talking about cancellation of removal, there are two types of cancellation of removal. One we call EOIR 42A. That is cancellation of removal by permanent residents. Those who already have green card but for some reason found themselves in removal proceedings, they can apply for EOIR 42A. That is cancellation of removal for legal permanent residents. Now, the second part of cancellation of removal is what is called EOIR 42B. That is cancellation of removal for non-permanent resident. Cancellation of removal for non-permanent resident. The reason I have to explain this distinction is because the requirements are different. The requirements are different. So if we are talking about cancellation of removal for non-permanent residents, there are three major requirements. One, an applicant or a respondent. When you are in removal proceedings, you become a respondent. You are not referred to as an applicant anymore. You are referred to as a respondent. Now, a respondent in a removal proceedings applying for cancellation of removal must show that, one, you must have been living in the United States, either legally or illegally, it is immaterial, but you must have been living in the United States for at least 10 years before the issuance of NTA. It is very, very important. Listen to what I'm saying, because this is something that is capable of being misinterpreted or being misunderstood. It is important to understand the 10 years has to be before the issuance of NTA. Any day that the notice to appear is issued, the date on that notice to appear put a stop to the accrual of physical presence in the United States. In other words, If you have been here for 9.5 years and NTA is issued, but that NTA was not filed in court for 2 years, maybe by the time they file the NTA at the immigration court, you have already been here for 12 years. When you go to court and request cancellation of removal, you will not be eligible, because when the NTA was issued, you were only here for 9.5 years. So in such a situation, you will not be eligible for cancellation of removal. In other words, what I'm trying to explain here is that the issuance of NTA, notice to appear, the issuance of NTA will stop the clock. Even if you stay here for another 10 years after the NTA has been issued, you will no longer be eligible for cancellation of removal. In fact, let me give you one example. I have a client here in this office that we have a hearing coming up. Yesterday, while I was reviewing the file, I just decided to check whether this client was eligible for cancellation of removal or not. Then I realized that in his own case, the NTA was issued since 2006. The NTA was issued since 2006. You can imagine, even between 2006 and now, that's more than 10 years. But unfortunately, this client is still not eligible for cancellation of removal, because the moment the NTA was issued, he put a stop on the counting of number of days that you accrue here in the US. So the 10 years must be before the issuance of the NTA. Now, there is something that I'm going to explain further on this 10-year thing, but let me just finish with the requirement of the cancellation of removal first. The first requirement, as I've explained, is to show that you have been here for 10 years. That's the first requirement. 10 years before the issuance of the NTA. The second requirement is to show that the respondent, you as the respondent, you have a qualifying relative. Now, the word qualifying relative means you have a family member who is either a US citizen or a permanent resident. And for immigration purpose, family member or qualifying relatives, it could mean your parents, your spouse, that is husband or wife, or your children, minor children, not adult children. Adult children are not part of your family for immigration purpose. So it has to be either your parents, your spouse, or minor children. That is what is called qualifying relative. So the respondent must have qualifying relatives who will show that they will suffer extreme hardship if the cancellation of removal is not granted. It is not enough to have a qualifying relative, but the qualifying relative must show that they will suffer extreme hardship if the cancellation of removal is not granted. That is proving extreme hardship. That's a topic for another day. Hopefully, one of these days, the podcast will discuss that, how to prove extreme hardship. But for this purpose, the requirement is that the respondent must have a qualifying relative who will have to show that he or she will suffer extreme hardship if the cancellation of removal is not granted. The third and the final requirement when it comes to cancellation of removal is to show that the applicant himself or herself, the respondent, is a person of good moral character. That is, the applicant is not disqualified on the basis of GMC, good moral character. So usually you have to show that the applicant does not have criminal record, or if there is any criminal record, it is not a crime of moral turpitude. So if it's a crime of moral turpitude, the cancellation of removal application will still be denied. Now, before I go further, let me go back to the 10-year requirement. Those are the three requirements for cancellation of removal. But I want to go back to the 10 years because there is something that some people, very limited number of people, not a whole lot of people, but limited number of people may still be eligible for, despite the fact that the NTA was issued a long time ago or despite the fact that the stop time rule of the NTA apply to them. Now, there is a case called Pereira v. Session. Pereira v. Session is a U.S. Supreme Court decision. In that decision, the respondent challenged ICE. They challenged Immigration and Customs Enforcement, stating that, look, when you issue this notice to appear, the notice to appear stated that I should appear in court on a date to be determined at a location to be communicated later. So they argue that because you did not provide the place, the date, and the time where I'm supposed to appear, that notice to appear is not valid for the purpose of preventing me from applying for cancellation of removal. Of course, the immigration court did not agree. They denied it. The respondent filed an appeal. The Board of Immigration Appeal denied it. The respondent appealed to the Federal Court of Appeal. The Federal Court of Appeal denied it, and then the respondent applied to the U.S. Supreme Court. So now, the U.S. Supreme Court now ruled that, yes, that NTA is not valid. If you don't put date and time, you cannot prevent an applicant, you cannot prevent a respondent from applying for cancellation of removal, because until the NTA is properly issued, such a respondent cannot be prevented from accruing additional number of days so as to be eligible for cancellation of removal. So the court, the Supreme Court, United States Supreme Court in Pereira v. Session issued that decision. So now what that means is that if you have a notice to appear that does not state specifically the location where you are supposed to appear, the time where you are supposed to appear, and the date when you are supposed to appear, if your NTA, the notice to appear, does not have all of these, you may be able to show that that NTA cannot prevent you from applying for cancellation of removal. Now, the government did not just fold their arms and agree completely with Pereira v. Session. So the government attempted to fix the problem by stating that when the court issued a hearing notice, even if your NTA, the notice to appear, does not have a date, place, and time, when the court issued a hearing notice, a second document, that hearing notice will tell you the location of the court, the date you are supposed to appear, and the time you are supposed to appear. That the issuance of that second document will cure the inadequacy that Pereira v. Session identified. Now, the Board of Immigration Appeal now ruled that if the court issued a second document, that second document will cure the initial problem. Again, some people filed an appeal against that decision. That appeal went all the way back to the U.S. Supreme Court. This was just last year, 2022. It went back to the U.S. Supreme Court, and the U.S. Supreme Court confirmed that, look, you cannot cure this problem by a second notice. The law requires that a notice to appear must contain those information, the place, the date, and the time where the removal proceedings will take place. If the notice to appear does not have it, any subsequent notice cannot cure that problem. So that means that Pereira versus Session is still a valid authority. So if you find yourself in this position, I advise you, contact your lawyer, let your lawyer fight for you. If you don't have a lawyer who understands all these things, I would advise you, maybe you need to change your lawyer, look for an experienced immigration attorney so that you don't lose the opportunity of what you will otherwise be eligible for. So those are the requirements for cancellation of removal. Now, let's go further with the questions. Next question. I've already been ordered removed. Can I still apply for cancellation of removal? Well, immigration is not a one-cap-fits-all. I cannot tell you whether you can still apply or not. But what I can tell you is that if you have already been ordered removed, you have 30 days from that removal order to file an appeal. So if you did not file an appeal, that means the order becomes final. You also have 90 days. If you have been ordered removed, you also have 90 days to file what is called motion to reopen. So if the 90 days has passed, it means you can no longer file a motion to reopen, you can no longer file an appeal, so that order becomes a final order. So even if you are eligible for cancellation of removal, there will be no opportunity to present it. The next question. I have a question about what you said earlier about rescission proceedings. My green card was terminated by USCIS and I was put in removal proceedings. Why did I not go through rescission? Well, if you have a green card and you are put in removal proceedings, that is good for you. Because if you listen to my explanation, if you are put in a rescission proceedings, you will not have the opportunity to apply for benefit. Because even the immigration court, their jurisdiction is only going to be limited to making a determination whether your green card should be rescinded or not. So they can't go into what relief are you seeking. They can't allow you to apply for cancellation of removal. They can't allow you to apply for asylum. They can't allow you to apply for any form of benefit. Rescission proceedings is exclusively for the court to determine whether your green card should be rescinded or not. Nothing more than that. The court does not have authority to do anything more than that. So if you are placed in removal proceedings, it is actually good for you, because in a removal proceedings, you will have the opportunity to present a relief that you want the court to look into. So that would be good for you. Next question. What does it mean if your cancellation of removal case is denied by the immigration judge at the individual hearing? What happens next? Well, as you already said, if your cancellation of removal is denied, it means it was not granted. So there's nothing I can say about that. However, what happens next determines whether or not you have other reliefs, or whether or not you presented a good case. Because, as I said, most people, even including lawyers, a lot of people don't know how to present a persuasive cancellation of removal when it comes to proving extreme hardship. I want you to notice the word, because I'm using this word carefully. I'm choosing them. They are not words that I'm just picking up as a form of English communication. The law requires you to prove extreme hardship. Look at that word, extreme hardship. So extreme hardship is not a definable word. It is not something that is just the effect of a normal somebody who is removed from the U.S. Of course, anybody who is removed from the U.S., their family are going to suffer some hardships. I mean, there will be hardship of separation. There will be hardship of maybe standard of living. There will be hardship of maybe you miss your family members, and those are not extreme hardship. So when it comes to extreme hardship, it has to be something that goes beyond the ordinary effect or ordinary consequence of removal. So proving in extreme hardship is very, very key to a successful cancellation of removal application. Now, having said that, what happens next? If you believe that you presented a good case, but for some reason the judge did not approve it, then you can file an appeal. The judge's decision is not final. You have the opportunity to file an appeal up to as long as you want. You can appeal to the Board of Immigration Appeal. If they take a decision, you still don't like it, you can go ahead to appeal to the Federal Court of Appeal. And of course, I can't guarantee that you can appeal to the U.S. Supreme Court, because unlike most other countries, the Supreme Court here, they pick and choose which case they want to take. They are not like some countries in Africa where every single case goes through the Supreme Court. Here, they will look at their precedent. If it's a case that they believe they have dealt with similar thing in the future, they refer you to the precedent. They don't need to waste their time. But if it is something novel, something they have not decided on before, that is when they will take it. So it is no guarantee that the Supreme Court will take your cancellation of removal appeal, but at least you can still fight it up to the Circuit Court, Federal Circuit Court of Appeal. So you can fight it. That one is as of right. So now, if you believe that you presented a good case, it was not, the judge just didn't approve it, then you can file an appeal. You can also seek a second opinion, because if you seek a second opinion and maybe the second opinion, they determine that there are things that your lawyer should have done which they didn't do, then you may still have the opportunity within 90 days to file a motion to reopen, to present additional evidence. Again, this becomes discretionary, because the judge may feel that you had all the opportunity, you should have presented all these arguments. Why didn't all these documents you are just bringing up, why didn't you bring them up before? But it becomes a discretionary thing for the judge to determine whether to reopen your case or not. But again, I cannot tell you what next without knowing the totality of your situation. But again, if you are ordered removed, if you don't appeal within 30 days, the decision becomes final. If you don't file a motion to reopen within 90 days, the decision becomes final. So that means you end up being removed from the United States. Next question. If the cancellation of removal is denied, can I be taken into custody right away to deport? How does that work? No. Remember, I explained earlier that immigration is not a criminal prosecution. Immigration court, immigration cases, they are civil cases. They are not considered criminal matter. So this is not a criminal matter. It is in a criminal matter that when you are convicted, you are immediately put in detention. You are arrested and put in detention. Immigration is not a criminal matter, because when an immigration judge order you removed, you still have a right of appeal. You can file an appeal within 30 days. So they cannot take you into custody without even knowing whether you want to exercise your right to appeal. So it doesn't become a final order until either the time for appeal has passed, or you have gone through the appeal process and your appeal has been denied. It is only after that they can put you in custody and then implement the court order. Another situation where they can put you in custody is if your case has criminal undertone. Again, even though immigration is not a criminal matter, but what led you to removal proceedings has something to do with crime? In fact, there are two types of removal proceedings. We have detained cases, we have detained docket, and we have non-detained docket. So if what puts you into removal proceedings, what led you into removal proceedings in the first place has criminal undertone, yes, you will be detained. And most likely you will have been detained even before the final removal order. But if you are not detained before the removal order and your case does not involve or does not have any criminal undertone, if you are ordered removed, because you have the right of appeal, which is still valid for 30 days, nobody will put you in custody. Next question. Can I work while I'm waiting on my application for cancellation of removal? Oh, sure. if you file an application for removal of, if you file a cancellation of application, cancellation of removal, excuse me, if you apply for cancellation of removal in a removal proceedings, that application by itself is actually an application for green card. And because it is an application for green card, every pending application for green card enables an applicant to apply for employment authorization. So while your case is not have any document for a full year in the middle of my 10 years here, will this cause issues with my cancellation of removal? Yes, it will cause issue, because when we are talking about cancellation of removal or any form of relief in a removal proceedings, it is the duty of the respondent, it is the responsibility of the respondent to meet your burden. As I explained at the beginning of this podcast, the government has the responsibility to meet the burden for putting you in removal proceedings. In order to meet that burden, that is why the standard of the charges in the notice to appear, they lower it. They only state things that they will be able to prove. You are not a citizen of the United States. It's so easy for them to prove it, because all they need to show is your passport. You are a citizen of XY country. Your passport will show. If you came in here with a visa, your visa will show that this is your home country. You went to maybe 6 months at the point of entry, so it's easy for them to prove. You remain beyond the period authorized. Those things are easy for them to prove, because if they gave you 6 months and your 6 months expire in July and you are still here by August, so that shows that you overstay. So the burden for them is so easy. And once they meet that burden and the court establish that removal has been established, and the court will now turn to the respondent, what relief are you seeking? So from that moment, it becomes the respondent's responsibility to meet his or her own relief. So if you are now applying for the relief of cancellation of removal, you are the one that will have to show. You can use things like tax return, you can use utility bills, bank statement. I mean, even purchases, even if you stay at hotel, if you fly from maybe one airline, maybe from Dallas to New York, things that show your physical presence here. And remember, there is also public record, but the government is not going to help you to prove your case. It is going to be your responsibility to prove your case. So if you said that you lost your job, you didn't have a job, therefore you didn't have a house, but you are still living with some people, there is no way. America is not a cash economy. There is no way you will be in this economy and you will not have record. Even if it is mails, do you receive mails? I mean, even if it is junk mails, there will be some form of paper trail, something that will show that you are here. What about driver license? What about ID? What about, do you have children in school? What about their school record? Do you attend a parent-teacher association meeting? Do you volunteer in the society? Do you buy groceries? There's no way you'll be here and you will not have all of these things. And again, people you live with, they can give you affidavits, sworn statements stating when you live with them. And of course, public record will corroborate that. But most importantly, it is your responsibility to show that you are actually here for 10 years. It is not the government's responsibility to prove that you are here. You will have to show that. Next question. I had a green card that was terminated. I have applied for cancellation of removal. If my application is granted, will they issue me a new green card, or do I use my old one? Yeah, if your cancellation of removal is granted, you will get a new green card. So you will get a new green card, because if your previous green card has been terminated, it means it's no longer valid. But it depends on, it is not every case of removal proceedings that the green card is terminated. For example, somebody who applied for what is called, that is not what we are discussing today, but I just want to clarify. Somebody who applied for what is called 237A1H waiver, if that waiver is granted, it dates back to the original green card. That waiver is like somebody who is granted a pardon. So it's as if that offense never existed. So if, for example, you have been a permanent resident for 5 years before you are placed in removal proceedings, if you are placed in removal proceedings and you are eligible for 237A1H waiver, and that waiver is granted, that means that the day they granted that waiver, you can apply for citizenship, because it restores your green card back to its original position. But that it is not the same thing with cancellation of removal. So it is very important that we understand that. Next question. Excuse me. Is there a difference in the cancellation of removal if my case is based on VAWA? Well, cancellation of removal and VAWA, they are not the same thing. They are two different set of relief. So if you are talking about VAWA, that is completely different. If you are talking about cancellation of removal, is completely different. So whether if you are a VAWA beneficiary, if you have a VAWA application that is approved, you apply for adjustment of status based on that VAWA. You don't apply for cancellation of removal. Cancellation of removal is an independent form of relief in a removal proceedings. It's an independent form of defense that anyone can apply for in a removal proceedings. And if you are granted VAWA, that is an independent way of applying for green card. So you just apply for adjustment of status based on the VAWA. So they are two separate things. They are two separate things. Okay, next question. How can I show good moral character? Oh, that's very easy. Good moral character, it simply means that you are a person that has not been convicted of criminal activities. You see, the word conviction is different from arrest. I'm not saying arrest does not prevent you from proving good moral character. Arrest alone does not prevent you from proving good moral character. It is only conviction that can prevent you from proving good moral character. And when we are talking about proving good moral character, all you need to do, apply for police clearance report from the state where you live. Or if you want to do federal, apply through FBI. Do FBI background check. Once it comes back and shows that you don't have criminal record, that is evidence of good moral character. You don't even need to present any evidence. All you need to do, apply to FBI for background check. FBI will send you a letter confirming that you do not have any criminal arrest. That is sufficient evidence of lack of good moral character. Or if you don't want to do FBI, you can apply for statewide if you have lived in one state. Or if you have lived in multiple states, then you have to apply for police clearance from every state where you have lived. But once you have that report come back and the report shows that you do not have criminal conviction, then that is evidence of good moral character. So it is the simplest thing to prove that you do not have a criminal record. Very easy. So just apply for police clearance certificate, and that will be enough to show that you are a person of good moral character. Okay, let the questions keep rolling. I think I've answered the last one. Let the questions keep coming in. So as I said, while waiting for other questions, let me give you an idea on how to meet each of these requirements for cancellation of removal. As I said earlier, there are 3 requirements for cancellation of removal. First, you have to show that you have lived in this country for at least 10 years. Second, you have to show that you have a qualifying relative, that is, US citizen or a permanent resident, parent, spouse, that is husband or wife, and minor children who are either US citizen or a permanent resident. And you have to show that these people will suffer extreme hardship if you are to be removed, or if your cancellation of removal application is not granted, that they will suffer extreme hardship. Now, how do you put documentations together to prove this? One, let me give you this caveat. I don't want to be misquoted. What we are doing in this program is to help people to prevent what I call avoidable mistakes, avoidable errors. Now, every statement that I'm providing today, or even in my previous podcast, they are not based on a particular case. So every case is different. It is always good for you to consult an experienced immigration attorney, because what you may need in your own peculiar case may be different from the general information that I'm providing. So I don't want you to rely on this wholeheartedly or as the only source without seeking an expert opinion on your peculiar case. Your peculiar case may need you to prove certain things which may not come up in this conversation. Your peculiar case may need you to provide a specific document which may not be relevant, which may not come up in this conversation. So I want you to understand, the immigration is not a one-cap-fits-all. It is not a one-cap-fits-all. So I want you to always keep that caveat at the back of your mind. Now, having said that, proving 10 years, like I said, there's a legal maxim that says, he who comes to equity must come with clean hands. If you have been living here for the past 10 years, you ought, and you are working and you are making income here, you are living here, you are paying your bills here, you also have a responsibility to file your taxes. Let me tell you, filing tax in the US is not peculiar to US citizens. It's not limited to permanent residents. It is not limited to people who are in legal status. Even if you are illegal, even if you don't have social security, even if you don't have employment authorization, you still have an obligation to file your taxes if you are working. Now you ask me, how am I going to file it if you don't have social security? That is exactly the purpose of tax ID. So if you go to a tax preparer, tell them you don't have a social security, they will file the tax return and then apply for ITIN together with your tax return. The only thing is that they will not be able to e-file your tax, because they will have to file it manually with IRS, because they are applying for tax ID. But the fact that you don't have social security is not a ground for not filing your taxes. So if you have lived here for 10 years and you don't have 10 years tax return, then it means that even you don't have the moral forthright to expect them to grant your application, because to whom much is given, much is expected. It is your responsibility. It's an obligation. If you are making money here, you are supposed to file your taxes. So tax return is one of those things that easily prove that you have been here for 10 years. And not only that, it also shows, it will also support the fact that you are a person of good moral character. Before I go further, let me say this. Irrespective of the requirement, every single application has what we call discretionary content. There is something that every adjudicator is required to look into, and that thing is your desirability as a permanent resident. Even if you meet all the requirements, Are you desirable? Is it in the interest of this country to let you become a permanent resident? Those discretionary considerations, if they see that, okay, this person has been living here in the last 10 years, he has not even paid taxes, this person is not going to be a good citizen, this person is not desirable, those are discretionary factors. They may not be specifically stated in a denial ruling, but those may be invincible consideration in your application. I use the word invincible because most judges will not say that, oh, I'm going to deny this because this person has not filed taxes. No, they will not write it. But it will be part of their consideration that, look, this person is not even a resident yet, he's already evading taxes. If we give this one green card, he's not going to be a good resident. So those are invincible considerations. And I can tell you for sure with authority that every single application has a form of discretionary content embedded in it. So it is always good for you to file your taxes. Even non-resident, people who are not here, who make money here, they are required to file taxes. So if you are living in Africa, if you are living in Europe, if you are living in South America, but if you are doing business and you are making money in the US, you have a responsibility to file tax return. That is why they have provision for non-resident filing. The Form 1040 NR, non-resident. So you don't have to start living in the US before you have the obligation to file taxes. For as long as you are making money here, you have a responsibility to file taxes. And let me say this, filing taxes is not the same thing as paying taxes. Because this is another thing that a lot of people make the mistake. If you are not living here, it is unlikely that they will ask you to pay taxes. But you still have a responsibility to file your taxes. It is when you file your taxes that you will state, you have the opportunity to tell them where you live. It is when you file your taxes that you will have the opportunity to tell them that you are actually paying taxes in your home country. It is when you file your taxes that you will have the opportunity to let them know that you will be paying double taxes if you have to pay another tax here. And I can assure you, and I do know, and I tell you authoritatively that if you are paying taxes in your home country, you will not be required to pay a second tax here. So, but again, that will not stop you from meeting your obligation to file your taxes. So very important. And that will also help you if you find yourself in a position to apply for cancellation of removal. So as I said earlier, in addition to filing taxes, lease agreement, mortgage statement, ID renewal, driver license renewal, mail. If you move, every time you move, you do a change of address with the post office. All those evidence of change of address, they are all evidence that you live here in this country. If you have children who go to school, their school record will list you as their parent or their guardian. All these things are evident. Even if they are not your children, if you are a guardian over other people's children, all this evidence will show that you live here. Your phone record, there's no way you will live in this country and you will not have a cell phone. I mean, your phone record, go to your carrier, get your phone record. Even don't you pay bills, you will pay your phone actually physically here in the United States. Now, going to the second thing, proving extreme hardship. Now, every case is different. In some cases, you may have a qualifying relative who has medical challenges. If you have a medical challenges, yes, that will help you to prove extreme hardship. If the qualifying relative has medical challenges, all you need to show is that you are the primary caregiver. If you are the primary caregiver, then if they send you out of the country or if they don't approve your cancellation application, apparently the qualifying relative will suffer. Who is going to be taking care of him or her? Even if the government takes over, it will still cost government money because it means the government will have to pay somebody to take care of him or her. So that's a way of showing extreme hardship. Because when we are talking of extreme hardship, even if you can show that, look, what you are doing will save government money. Okay, this person has a medical condition. I'm the one that takes care of him. And because I take care of him, the government does not have to pay a caregiver. The Medicare does not have to pay another person to have this person taken care of. So all these things, those are additional evidence of the hardship that the qualifying relative will show. Again, it depends on who the qualifying relative is. Where the qualifying relative is an elderly person, maybe your parents who are already aged, you can also show that you are the primary caregiver. These people are old. They need you. You are the one that takes them to their hospital. You take them for their medical appointment. You care for them. You are the one that meet their need. Maybe you even house them, or you pay their fees in old people's home or wherever they are. So you show all these things that you do, and you now show that if this application is not approved, if you have to be removed from the US, your parent will suffer because there will be nobody to do all these things. And even if the government were to appoint somebody else to do it, it will cost the government money to do these things. So it's like you are stating what value you are bringing, you are adding to the life of this person. And if that value is removed, the person will suffer. So that is another thing. Again, depending on who the qualifying relative is. If the qualifying relative is your spouse, well, in my opinion, that is actually one of the easiest things to prove, because one of the reasons people get married is companionship, is sexual relationship. So if you are separated from your spouse is going to lose all these benefits. Maybe you are planning to have more children. If you are separated, if you are removed from the United States, how is your spouse going to have the children? You are not going to be able to have sexual relationship. You are not going to be able to have companionship. Let me tell you, loneliness kills. Loneliness kills people. And this is part of the areas. It does not matter what your culture is. Whether you are African, you are Hispanic, you are American, it does not matter. Everybody needs a companion. So if your qualifying relative is a spouse, yes, you should be able to emphasize all those things that will make your spouse suffer extreme hardship if the application is not approved. Again, if your qualifying relative are minor children, the reason why I was emphasizing minor children is because it's going to be extremely difficult for you to prove hardship to children that are adults. Adult for this purpose, any child that is over 18, any child that has graduated from high school, any child that is in college, it's going to be difficult for you to prove extreme hardship. I mean, if the child is already in college, apparently you are not even living together anymore. You are not the one taking care of this person in college. So how can you prove any hardship? But if the child is a minor child, the one that you have to take to school every day, you have to pick up from school every day, the one that you have to guide to do the homework, the one that you have to take to sporting activities, the one that you have to take to maybe amusement park or maybe take to field trips, all these things, those are going to be evidence of hardship. If you are not there to do all these things, their child will suffer extreme hardship. So it's going to be a combination of factors, accumulation of factors. Again, every case is different. So you look at your peculiarity in order to come up with what would be in your best interest. Let's keep going with the questions. I think we have more questions. Okay. I applied for the adjustment of status through marriage, but it was denied in 2021. I was instructed to leave US within 90 days. The letter sent to me by immigration, I have not done anything to that effect. I have not done anything to to that effect since then? What do I do now and when I intend to reapply? Again, these are questions that is difficult to this question is difficult to answer because I really don't know a whole lot. So it is not enough to just say that you apply for adjustment of status through marriage. That may not be enough because one, I don't know why the application was approved. If, for example, the application was denied because maybe immigration found that your marriage was not legit, Section 204C of the immigration law will disqualify you from having any future petition to be approved. Section 204C of the immigration law says no petition shall be approved where the alien has previously been accorded or has sought to be accorded a preference category by reason of a marriage to a United States citizen or an alien lawfully admitted to permanent residence by reason of marriage determined by the Attorney General to have been entered into for the purpose of evading immigration laws, or determined that the alien has attempted or conspired to enter into a marriage for the purpose of evading immigration law. Well, for students of English, you know that whenever the word shall is used, it means compulsory, it means compulsion. So no petition shall be approved. So what that simply means is that if the initial petition was denied because immigration concluded that your marriage was not legit or your marriage was fake, so any future petition will be denied because the approval of a subsequent petition will be prevented by Section 204C of the immigration law. And again, for such a person, even if you are eligible for cancellation of removal, this brings up another issue under good moral character. Even though marriage fraud by itself is not a ground for denial of cancellation of removal, but these are some of the invincible considerations that the judge may look into. A judge who believes that you have entered into a fraudulent marriage may not find you to be a person of good moral character, even though it will be more than the judge will have to have more than that. But again, if your case is falling on a 50-50 scale, the judge may use that as a consideration not to approve your petition or your application for cancellation of removal. So very important. So it is important to know why the petition was approved before I can give you a definitive answer as to what you can do next. So either you provide more information here for me to work with, or based on everything that I've explained, you can make the conclusion yourself and see whether or not you are eligible for cancellation of removal. Okay, keep the questions coming. Keep the questions coming. This is a program we are doing every Wednesday, every single Wednesday, to provide information to our people, to ensure that people avoid simple mistakes, simple errors, things that can get them into trouble. We are not doing this to make money. It is just our own way of paying back to the community, giving back to the community. So invite your friends, invite your family, subscribe to our channel so that whenever we go live, you will be notified. And join us every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. So keep the questions coming. Keep the questions coming. Okay, I have new question here. How long does the cancellation of removal process take? Well, again, these are questions that I cannot answer. These are questions that are extremely difficult to answer. Anywhere in the world, nobody can tell you how long a court proceedings will take. Because this is a court proceedings, it is extremely difficult for me to tell you how long it will take. However, one thing I will tell you is, if you receive an NTA and you know that you are eligible for cancellation of removal, if you discuss this with your lawyer and your lawyer believes that you are eligible for cancellation of removal, you can do several things to fast forward your case. One, you can prepare and file your application of cancellation of removal without waiting for the court date. Because sometimes we are in 2023 now, sometimes you may receive a hearing notice that will tell you to come to court in 2025. You may receive a hearing date that tells you to come to court December 2024. Meanwhile, we are just in April 2023. So if you know that you are eligible for cancellation of removal, go ahead, prepare your application, file the application in court. Once you file the application in court, submit what I call written pleadings. So let your lawyer submit a written pleading. So even though your case has not come before the court will see your written pleadings, how you intend to plead to those allegations in the application. So you admit those allegations, you concede the charge, you present your relief in the form of cancellation of removal, and then you submit your application for cancellation. If you do all of those things, and then you can now submit a motion to advance hearing date. So if you submit a motion to advance hearing date, then the case will be brought forward. So your case could be finished in 1 year. But again, it is an optional thing. It is not that I can guarantee you that, oh, your case is going to finish in 1 year. No, every case is different. And in some cases, again, this is why it is not good to stereotype cases. Every single case is different. There may be situations where you may be eligible for cancellation of removal, but maybe, let me give you an example. I once represented a client who I believe is eligible for cancellation of removal. However, the qualifying relative, the children who are the qualifying relative, they are already teenagers. One was already 18, the second one was already 17. Now, if you set this type of case for individual hearing, there is a risk because, like I said, it is difficult to show hardship to a teenager except they have medical challenges. An 18-year-old who has already graduated from high school, who is already going to college, who is living in college, you don't live with them. So it's going to be difficult to prove hardship to such a child. So in such a situation, even though you may be considering cancellation of removal, but we may also want to intentionally delay your case to enable that child to turn 21 so that you have an alternative relief. Because now, depending on the specific situation of your case, that child, if he or she turns 21, all he needs to submit for you is just a relative petition. That would be straightforward. You do not need to prove any extreme hardship anymore. So if your case is in that borderline, if I am the one representing you, I will advise you to be patient. So rather than push the case, we intentionally delay the case so that that child turns 21 in the process and you have a plan B, in fact, a better option than the cancellation, because of the inability or the difficulty that we will face in proving extreme hardship to those teenage children. Let's see question. Okay. The next question, what happens after cancellation of removal is granted? Well, cancellation of removal is actually a permanent resident. So if a cancellation of removal is granted, you become a permanent resident from that day. So if your individual hearing is today, and after the hearing, the court said that I'm going to grant your application, it means that from that day, you become a permanent resident. So that order will be forwarded to immigration, USCIS, and then USCIS will now have to produce your permanent resident card and mail to you. But from the day the court grants cancellation, you become a permanent resident of the United States on that date. Next question. If I previously had a green card that was terminated, then I receive a new one. Once the cancellation of removal is granted, will the residence since date be the date or the date that the cancellation of removal was granted? If it is the old date and I'm otherwise eligible for citizenship, can I apply right away? Yes. Ordinarily, if you had a green card that was previously terminated and you apply for cancellation of removal, you are supposed to be a new permanent resident. However, if immigration issued a green card that has residence since and it had your old date, yes, if you are eligible for citizenship, go ahead and apply, because for the purpose of citizenship, it is the residence since that counts. So if the residence since was backdated to your initial date, yes, you are eligible for citizenship right away. You are eligible for citizenship right away, yes. Next question. Can a deported person come back legally by marrying a U.S. citizen? Well, that's not a yes or no answer, because in order to determine whether you can come back by marrying a U.S. citizen, we have to look at why you were deported in the first place. Because if you go back to some of the things I said at the beginning of this podcast, I stated that even a permanent resident can be deported. So if a permanent resident who committed aggravated felony offense was placed in removal proceedings and then ordered removed, then if you marry a U.S. citizen, that cannot fix that problem, because it means that you will not be able to overcome the grounds of inadmissibility. But if you are deported, probably because you didn't have a relief, yes, you will have a 10-year bar, 10-year post-deportation bar. But if you are married to a U.S. citizen, you can file I-212 waiver together with I-601 waiver. And then if granted, yes, you may come back. But again, it is not every case where you can come back, because if what led to your deportation is a ground that you cannot overcome, when marrying a U.S. citizen cannot solve the problem. Let me give you a couple of examples of grounds that you may not be able to overcome. I've stated many times during some of our earlier podcasts that there are certain things that create a permanent bar to somebody from getting a green card in the U.S. 3 things basically create a permanent bar. 1, somebody who is convicted of aggravated felony. Now, if that person who is convicted of aggravated felony, except the person is eligible for readjustment, it is not everybody that is eligible for readjustment, except the person is eligible for readjustment, such a person, if the person is removed, you may not be able to come back to the U.S. even if you are married to a U.S. citizen. However, if the person is eligible for readjustment, then you may be able to come back to the U.S. upon marriage to a U.S. citizen. That is one. Another thing that can prevent somebody from being able to come back, somebody who filed what immigration determined to be a frivolous asylum application. If immigration makes a determination that your asylum application is frivolous and they deny it after trial based on frivolity, even if you marry an American president, you cannot come back because that is a permanent bar. That is a permanent bar. That is the law. You cannot come back, irrespective of who you marry. Another thing that creates a permanent bar, I just stated that a few minutes ago. Section 204C of the immigration law. If under Section 204C of the immigration law, if immigration makes a determination that your marriage was fraudulent, that your marriage was fake, and then deny it upon that finding and deport you as a consequence. So even if you remarry another American citizen, you may not be able to come back. So it depends on why you are deported in the first place. So that is why I said it's not a one-cap-fits-all. It's not a yes or no question. So I cannot determine whether you may be able to legally come back by marrying another U.S. citizen. Next question. What is the difference between removal and deportation? Apparently, this person just joined us. I explained this earlier. Deportation proceedings, that was the old language. That was the old language of the law. And initially, they used to call them, they used to call the proceeding, it's the same exact proceeding. It is just it's a matter of semantics. It's a matter of language. Removal proceedings is what they call it now. In the past, years past, they used to call it deportation proceedings. At the time when they call it deportation proceedings, they used to issue what is called order to show cause. Order to show cause. So if you are placed in deportation proceedings at the time, you'll be given a document called order to show cause, meaning that come and tell us why you should not be removed from the United States. So the charging document is called notice to appear. So now you have to appear in court and answer to the allegations against you. So technically they are the same thing, but it's a matter of semantics. In the past, they used to call them deportation proceedings, but now they call them removal proceedings. So it is basically the same thing in different language. Next question. Is there any situation where someone has been convicted of an aggravated felony can still be granted cancellation of removal? I doubt it. I doubt it. I don't think that will be possible. I don't see anyone who has been convicted of aggravated felony getting cancellation of removal. The simple answer is the simple reason is this. One of the requirements for cancellation of removal is to show good moral character, is to show evidence of good moral character. It is to show that the person is a person of good moral character. There is no way you can show good moral character if you have been convicted of aggravated felony. It is not possible. It is not possible. You cannot meet the requirement of good moral character if you have been convicted of aggravated felony. It's not possible. The only thing that somebody who has been convicted of aggravated felony may be able to do, not in all cases, in some cases, the only thing they may be able to do is readjustment with a waiver. That's the only thing. They cannot qualify for cancellation of removal because they will not be able to show evidence of good moral character. Good moral character and aggravated felony conviction, they are inconsistent. If you can say that somebody who has been convicted of aggravated felony has good moral character, then who will be determined not to have? It means that almost everybody, every convicted criminal will still show that they have good moral character. So that's not possible. Now, the next question, follow up. Okay. If I'm otherwise eligible and the felony is from a long time ago, for cancellation of removal, is not about how long the felony is. Good moral character is not about how long felony is, because like I said, aggravated felony is something that is serious. It's a very serious offense. Arriving alien, and they will be placed in removal proceedings. And when an arriving alien is placed in removal proceedings, they will be detained. They will not even be eligible for bond. They will be detained. So aggravated felony is something very, very, very serious. It's not that easy. So even people who already have it, they will still take the green card from you. So it's not that easy. So now, can I, before I go into the next thing, to let you know that I'm still on this question about if I'm otherwise eligible and the felony is from a long time ago. To let you know that the duration of aggravated offense does not matter. I know someone I know someone, let me leave it at that, who was convicted of aggravated felony in 1982. 1982 to this time, that is 41 years ago. 1982. And he was just recently arrested. He didn't even travel. It was during this Donald Trump administration when enforcement was high. They went to his job and he was even working for the government. Somebody who has been a permanent resident prior to 1982, but was convicted of aggravated felony in 1982. During the recent Donald Trump administration, he was picked up at his work, and this person was even working for the government. He was working for a state government. He was picked up for an offense of 1982. He didn't commit any new one. It was that same one. So longevity does not affect conviction for aggravated felony. The only thing that longevity may affect is arrest, not conviction. Once you are convicted, you are convicted. I mean, once you have convicted a fellow, you are convicted, you are convicted. A lapse of time does not affect it. So very important. Next question. Can I use digital data as evidence of residence, such as Facebook post if they have a location or tag Uber record? No. I don't think so. Yes, maybe Uber, because Uber will show your location from where you, but I doubt it if they will even accept Uber, because for Uber, you can actually make payment on behalf of somebody. You can pay. You can log into your app and tell them to pick up your friend from one location to another. So that does not prove that you are the one that is making that trip. And of course, they are not going to look at Facebook post. I mean, come on, Facebook post. Anybody can post anything on Facebook. So even if you are outside the US, you can give somebody your Facebook account in the US and ask them to post certain things on your behalf. Nobody is going to rely on frivolous things like that. That will not carry. I mean, if I'm the lawyer representing ICE, I will just tell the court to dismiss those things. Those things does not prove anything. And of course, I can assure you the judge will agree, because truly it does not prove anything. Those things are capable of being manipulated. So those will not be valid evidence of your stay in this country, because those things are capable of being utilized by other people. I mean, even recently, you see Netflix talking about people sharing passwords. So, I mean, anything that other people can have access to is not going to be accepted as evidence in this type of proceedings. And because you have the burden, so you have to go more. So that will not be enough. Yeah, keep the questions coming. We still have a few more time. We still have about 17 minutes to go. Keep the questions coming. And again, remember to invite your family and friends. Remember them to join us every Wednesday, 12 p.m. Central Standard Time. We are doing this to help our people, to provide information, to prevent our people from making avoidable mistakes. So do not be selfish. We are not charging for it, so do not be selfish. Invite people, invite your friends, family. Let them subscribe to our channel so that when we go live, you get the notification. So don't be selfish with this information. So invite people, invite other people. Keep the questions coming. Today we are discussing cancellation of removal. Keep the questions coming. Keep the questions coming. We are discussing cancellation of removal today. So cancellation of removal, we spend a lot of time on cancellation of removal for non-permanent resident. Now, for cancellation of removal for permanent resident, they do not need to prove 10 years. They do not need to prove 10 years. They are only required to show that they have been here for 7 years, and they do not need to prove the 10 years, unlike cancellation of removal for non-permanent resident. And again, for somebody who is already a permanent resident, there are other reliefs that may be easier to prove if you are already a permanent resident. Because for a permanent resident to apply and prove cancellation of removal successfully, you still have to meet certain requirements. But there may be other easy way out. For example, 237A1H waiver is only two requirements. The first requirement, the applicant or the respondent must show that he or she obtained a green card by fraud. Maybe you got your green card based on fraudulent marriage. Maybe you got your green card based on misrepresentation. Maybe as at the time you entered the United States as a permanent resident, maybe you have a U.S. citizen parent who petitioned for unmarried child of a U.S. citizen who is outside of the United States. The petition is approved. The applicant went through consular processing. At the end of the day, the U.S. Embassy in the home country decided to issue a visa, immigrant visa, for that person. But now, maybe before that person entered the U.S., he or she decides that the moment that marriage happened, that person is no longer eligible. So now, if such a person, maybe later, the now stated is married, they asked for the date of marriage, he or she listed the date of marriage, and that at that stage, immigration will pick it up. Oh, this person entered the U.S. unlawfully, because as at the time of entry, that visa was no longer valid. Again, if you are in this situation, what you can do is to apply for 237A1H waiver. The waiver requires you to prove only two things. One, that you obtain your green card unlawfully or illegally or fraudulently. That is one. Two, all you need to show is that you have a qualifying relative. Now, unlike cancellation of removal, you don't need to prove hardship to nobody. You just need to show that, oh, you know what? I have a U.S. citizen child. That's it. Or I have a U.S. citizen husband. Or I have a U.S. citizen parent. That's all you need to show. You don't need to show hardship to nobody. So that one is much, 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 much easier to prove than cancellation of removal. So that's why sometimes it is always good to consult with an experienced immigration attorney so that you weigh your option. You cannot see something easy and then you go for the long one, so that you don't make your journey to become an Israelite journey. The journey of 40 days turning to 40 years. You don't want to do that. Next question. For cancellation of removal, the hardship is not about you. You are not the government does not care about you. You are the one that violated the law in the first place. So this is not about you. This is about the qualifying relative. So it is the qualifying relative who will come to court and present his or her hardship. So it is not only the issue of coming to court, it is the qualifying relative who will have to testify and state what those extreme hardship are. It's not about you. So in fact, if you don't present the qualifying relative, then there's nothing to adjudicate. So there's no way you can get the cancellation of removal approved, because it's not about you, it's about that US citizen or permanent resident qualifying relative who will suffer hardship. So the hardship is not about you. They don't care whether you suffer hardship or not. You are the one that violated the law in the first place. So the entire case is based on the extreme hardship that the qualifying relative will suffer. So not only do they have to come to court, but they have to present a convincing testimony in order to get the cancellation of removal approved. Next question. How many times can I apply for cancellation of removal? Good question. That's a very, very, very good question. Cancellation of removal, you can only apply once. You can only apply once. It is not something that you get cancellation of removal today, they restore your green card, then you go and commit another offense, you come back, you come and apply again. No, it doesn't work like that. It's a one-time thing. It's a one-time thing. You can only apply for cancellation of removal once. So usually, whenever cancellation of removal is granted, in fact, every single case that I've done and where it has been granted, the judge will always warn you that, look, we are granting you this cancellation of removal. This is your only chance. Don't find yourself in my courtroom again. If you ever come back to this courtroom, you don't have the opportunity again. We are giving you this one time. So in fact, I think it's even part of the regulation for the judge to admonish you, to let you know that is a one-time chance. So it's a one-chance situation. It's not something you can apply over and over and over. No, you cannot. You can only apply one more time. One time. Now, you may be able to apply for other reliefs, but you cannot apply for cancellation of removal more than once. So it's only one time. However, you can apply for cancellation of removal for non-permanent resident once. Then if you become a permanent resident and you found yourself in this unpleasant situation, you can also apply for cancellation of removal for permanent resident once. But for each category, you cannot apply more than once. It's only once that you can apply. So we have about 7 more minutes. Please keep the questions coming. And remember to subscribe to our channel so that whenever we log on, you get notification. Remember to invite family and friends. You can send your questions ahead of time. Our number is 817-883-4495. 817-883-4495. Yeah, you can send in your question ahead of time. And if you have topics that you want us to discuss, you can send the topic in ahead of time and we will consider it. But starting this week, we are discussing removal defenses. People in removal proceedings, what options do they have? We are discussing removal defenses. So that is a series that we are starting this week. So today we are only discussing cancellation of removal. So next week we will probably be discussing another form of relief. Since we have dealt with asylum extensively, so I'm going to skip asylum, but we'll probably be discussing maybe withholding of removal or protection under Convention Against Torture. So if you have topics, send them ahead of time. If you also have a peculiar topic you want us to discuss, you can send it in ahead of time. Again, our number is 817 883 4495. 817-883-4495. This is a dedicated number for our podcast. So if you send in your question, you can be sure that we will treat it either during or before our podcast. So we'll continue next week with removal defenses. So it's a series that we are starting this week. So send in your question, invite your friends, invite families. You may think that this thing does not affect you, but who knows? You may know someone who is affected. You may have family who is affected. You may have friends who are affected. You may even know somebody who is a permanent resident today who is thinking that, oh, all this thing does not concern me. Then maybe tomorrow something happens. You find yourself in a situation. The experience you have, the information you have now is going to come to play. So you never know. So until you become a U.S. citizen, all these things, even if you're already a U.S. citizen, it may be somebody to you, close to you. There's a proverb where I come from that says that, how do I interpret it in English? That if someone is going to prevent you from having, if somebody is going to create a sleepless night for you, you might want to prevent that person from having sleepless nights, so that at least both of you can sleep maybe quite well. So hopefully you get the gist. It's not an English proverb, so I was trying my best to translate it. Okay, we still have a couple of questions, so let's go. The next question. During a different podcast, you mentioned becoming a public charge as ground of inadmissibility. If I have been told I'm inadmissible based on being a public charge, does this apply for cancellation of removal too? Well, this is a very good question, because for cancellation of removal, I mentioned 3 requirements. The first requirement is to show that you have been here for at least 10 years. The second requirement is to show that you have a qualifying relative, a U.S. citizen or a permanent resident, parent, spouse, or minor children who will suffer extreme hardship if the cancellation is not approved. Then the third requirement, this is where the issue of public charge may be relevant. The third requirement is to show that you are a person of good moral character. We call it GMC requirement, good moral character. Now, so many things constitute good moral character. Here, in proving that you are a person of good moral character, basically, you show that you don't have criminal record. That is the main thing. You don't have criminal record. That is the main thing. However, from experience, especially where the cancellation of removal is kind of 50-50 chance, where your evidence is not overwhelming. This third requirement, this requirement of good moral character, so many things can affect the judge's decision. Some of these things are things that the judges may be able to put down in writing as valid reason. Some of these things, they may be invincible reasons that the judge may not be able to write down, but we actually consider in determining this. And for somebody who is getting public charge, again, legally, talking about requirement is not a ground for denial. But in determining whether you are a person of good moral character, the judge may look at it, especially where the judge believes that you are not eligible for what you applied for. Let me give you an instance. I did a case of cancellation of removal a long time ago. This was a long time ago, probably around 2005, 2006. The judge denied the case because the respondent, in his tax filings, he was already defrauding the US government. This guy was making a lot of money, but he was also self-employed. So in his tax return, he will file Schedule C and claim all of his income. So instead of paying tax to the government, he will end up collecting tax refund. Unfortunately, this issue came up during the individual hearing. The judge was pissed off. In fact, the judge actually wrote it in his ruling that, look, if this person, who is not yet a permanent resident, is already avoiding taxes, is already defrauding the government, is already depriving people who are legitimately paying taxes, is already defrauding them of benefit they could have enjoyed, that this person is not fit to be a permanent resident. Yes, those are external considerations, but can it be considered? Yes, it can, especially where the evidence of cancellation of removal is like 50-50. Where the evidence is overwhelming, yes, this may not matter. But where the evidence is not overwhelming and the court is looking at, should we approve it, should we not approve it, all these little factors can matter. So that is where it can be applicable. So I hope I've been able to answer the question. This is 2 o'clock, 2:02 precisely. Today we will have to round up here and come to the end of this program today. Next week will be another day. Remember to invite your family and friends. And like I said, today we are starting removal defenses. We are starting a series, removal defenses. So cancellation of removal is just one of the removal defenses that someone in removal proceedings may present to the immigration judge. So we are starting removal defenses today. So that is what we discussed today. So next week we will continue, but it will be a different defense. So hopefully you will join us again next week. Remember to invite your family and friends. Remember to subscribe to our channel so that when we go live, you will get our notification. Also, remember to send in your questions ahead of time. If you have questions, if you are already in removal proceedings and you have questions, send in your questions. If you know other people who are in removal proceedings, you might want to tell them to join us. You never know who will benefit from this free information. This is our own way of giving back to the community, giving back to the society, especially our own people. This is our own contribution to goodness of life. So we are not charging for this. The only thing you can do to appreciate us is to invite family and friends so that you are not selfish with all of this information we are passing to you free of charge. Remember, immigration is not static. Immigration is not a one-cap-fits-all. Every information we are providing now is of general nature. If you have a specific case, it is better to consult with an experienced immigration attorney so that they look at your own specific case and advise you accordingly. So remember to join us next week, 12 p.m. Central Standard Time. See you then. Thank you once again for listening.
The principle was that it was a man that you can rely on. They work with me, they work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody you are it's providing you service, right? So it became something like a family. So yeah, I can see the relationship was good working with his staff. People give me encouragement, but I will look at it and say, how is it possible? You know, I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But he knew what he was doing. Like I said, research is very, very important. You know, if you do research, you will learn a lot of stuff. You know, there are a lot of immigration rules some people don't look at. You know, there are loopholes there, and sometimes they purposely put them there. You know, so it's research, and it's using those research to help a lot of people, not just me. It is not just me. It is a lot of people here that, many people here that he has helped. Many people. Sometimes it doesn't even charge them. You know, when it comes to the point that it doesn't even charge them. You know, so yes, if you are looking for an immigration lawyer, you know, even if I'm sleepy right now, if I'm like sleepy, you wake me up, you say, do you know any immigration lawyer? I won't even blink, you know. I will say it, Dr. Asekun is there, you know. I will just say it. So, yeah, that's how good he is.
Talking about immigration, as an immigrant myself, I always put myself in the shoes of clients because I've passed through the immigration process and I know how hard it can be on people when they don't have the legal documents to work or to do day-to-day activities here in the United States. So that personal touch makes a big difference.
The law office of Olu Asekun is special because we like to put ourselves in our client's shoes.
For Dr. Asekun, for me, I will forever be grateful, and I keep telling people he's the best immigration lawyer you can have. You know, he's the best immigration lawyer you can have. My first impression was that he was a man that you can rely on. They work with me, you know, they work with me like, it became something like.
Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I was okay, I'm coming to your office. He said, okay, but just drive carefully and things like that. So okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I held his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating, as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in our face, and we were able to get her substantial amount of money from the insurance company. Even after paying all our medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own. And we all celebrated. It was a good thing.